Hello, my name is Ana Rita Gil, and I am professor at the Faculty of Law, University of Lisbon. My paper concerns migratory crisis as the new normal on a multi-conflict era, the need for a new legal paradigm. In this paper, I discuss the traditional legal paradigm of international migration and refugee law, which is still based on the archetype of state sovereignty, on controlling who enter and remains in their territory, and the recognition of exceptions which are based on human rights, namely on protection of refugees. This traditional law has been questioned recently due to the current massification of migratory flows, mainly due to wars and persistent conflicts that challenge state sovereignty and their willingness to control all those that enter and remain in the territory. Indeed, faced with mass displacement, states continuously have been disregarding their human rights obligations, reinforcing restrictive measures to fight against all those that are seeking their territory to enter. Therefore, it seems like a true state of nature have taken place of respecting international refugee and migration law. I will start to characterize this new normal of constant mass migration, and then we'll analyze the traditional answers that still base the current legal framework on asylum and migration. I will show that due to mass displacement, states are no longer willing to respect these traditional norms. They are indeed losing their force in practice. Finally, I will draw some thoughts to help us think on a new paradigm that may help states to govern mass migration and at the same time to respect the human rights of all those affected. So let me start by the introduction to characterize the migratory flows in the 21st century. Much has been said about these migratory flows. They are steady, massive, and heterogeneous. Many scholars have also pointed out the need to rethink the traditional legal responses to this social phenomenon. The answers, it is often argued, have to go through the reinforcement of international law in this context. Indeed, although migration is naturally a matter with international nature, it is also a topic where the claims of state sovereignty are especially strong. So the traditional approach of international migration law respects and starts from the recognition of the principle of state sovereignty, but it affirms its limits, which are grounded on the need to guarantee human rights. For example, to protect international persecuted persons. However, this modus operandi usually calls for a case-by-case approach, which can be dysfunctional in contexts of migration crisis, as mass displacement due to wars and conflicts traditional tend to be. So, there have always been migratory flows, and all the various types that characterize migratory flows will continue to happen in the future, both voluntary and economic migrations, for migrations, migrations due to poverty, migrations driven by the mere desire to improve the quality of life, migrations caused by war and conflict, family migration, and even environmental migrations, just to name a few. The so-called pull factors that attract migrants are today more strong because we live in a more globalized world where countries seem closer. So it's now easier to be aware of these promised lands, countries where life can be more prosperous, or safe havens, and where people's rights are more respected. The speed and ease of information flows make clear for those who want to improve their lives what do other countries have to offer, their developmental level, how do they guarantee people's rights. But push factors, so factors that push migrants out of their countries of origin, have also increased, particularly those that lead to mass movements, such as climate change, also the persistence of armed conflicts and persecutions. We have assisted lately on not only some regional and medium level conflicts that tend to continue, but the emergency of new conflicts that naturally lead to mass displacement. So we may characterize the flows of nowadays era with some characteristics. One, their massification. Two, their heterogeneity. And three, their speed. Migration flows with these characteristics are being more and more frequent as the so-called 2015 EU refugee crisis or the 2022 displacement from the war in Ukraine both demonstrate. This is so striking that quite often we witness migration scenarios being called as crises. In fact, migratory crises or refugee crises seem to be succeeding constantly in the globe. To start with, migratory flows are now massive. This means that they may easily reach millions of persons. According to data from the United Nations High Commissioner for Refugees, a record of 100 million displaced persons were reached by 2022. In the so-called 2015 refugee crisis, about 1.3 million migrants tried to reach the European Union. That number was even more impressive in 2022 in the wake of the war in Ukraine, where in a few months, 7 million persons had already abandoned their country and reached the European Union member states. On the other hand, as I said, many of these mass flows are heterogeneous. They are formed by different types of migrants, individual migrants seeking a better place to live, people who, being individually persecuted, seek international protection or asylum, groups of people fleeing conflicts or disasters in their country of origin, and also mixed flows, which bring together persons belonging simultaneously to the previous three groups. So the world is currently faced with all these kinds of movements. In recent years, the European Union was confronted with flows belonging to the two later groups. In 2022, the Great Migratory Challenge was characterized by the massive flows of displaced people fleeing Ukraine consisted of a very numerous and very fast-growing flow of displaced persons. The scenario of the so-called European Union refugee crisis of 2015 was different. It was characterized mainly by mixed flows. In addition to many people fleeing wars and armed conflicts, namely from Syria, there were thousands of migrants leaving political instability, notably from Iraq or Afghanistan, or dictatorial political regimes, such as that of Eritrea. These flows were also joined by the so-called economic migrants coming from sub-Saharan countries who were seeking the EU member states to find better conditions of living. So these are the new migratory flows, massive, heterogeneous, and speed. Let's now face them before the traditional responses of public international law. And these traditional responses must be challenged before the reality of present and future migratory flows. In the context, one cannot speak of a monolithic linear history of a single paradigm. In fact, what is considered as the traditional responses of international migration law are based on a basic premise, which, as I said before, is not that very much international. It is the principle of the state's sovereign powers as regards immigration control. Indeed, international refugee and migration law was developed based on the dogma according to which the control of the entry and stay of foreigners in the territory is part of a core element of the state sovereignty. This is because migration is considered to have a deep impact on the elements of the state, as stated by Jelinek, and as they would receive formal recognition on the Montevideo Convention on Rights and Duties of States of 1933. In particular, it is easy to understand that they have an impact on the territory element, also on the population. Moreover, they have impact on the state's fundamental responsibilities in the pursuit of the so-called common good, understood as encompassing the regulation of labor market, the defense of public order, and national security, and also the preservation of national cultural identity. So this all makes the state very willing to maintain their controls on their borders. After the end of the First World War, the paradigm of the passport control was spread out through all Europe. But it was precisely in this period and in the periods that followed the two world conflicts that the counterpoint of the affirmation of the sovereign powers have emerged. This counterpoint was the recognition of the need to protect human rights of migrants. Indeed, if it's true that states were more and more willing to control their borders, it is also to be highlighted that soon after First World War, several instruments were adopted in order to protect persecuted groups, such as the agreements for the protection of Armenians and Syrians, Turks in the 20s. After the Second World War, the international community was willing to protect persecuted persons more generally. As such, the 1951 Geneva Convention on the Status of Refugees was signed. Contrarily to the previous instruments, it provided for the protection of individuals regardless of their origin, as long as they were persecuted because of their race, nationality, religion, or memberships of a special social group. Also, another limit to the state's powers of using includendi and excludendi, meaning control of migration, was developed with the recognition of universal human rights. As we know, public international law after World War II was characterized by a deep humanization. With the affirmation of these human rights, several international organizations made the point that also control of borders had to respect human rights of all migrants. So international human rights, a growing branch of law at the time, quickly demanded that the paradigm of the state's sovereignty and migration should be limited when human rights were at stake. For example, the jurisprudence of the European Convention of Human Rights guaranteeing bodies, the Commission on Human Rights first and European Court later, followed by several committees of United Nations, found the almost optimal formula for articulating the two interests involved in a migration case. In their decisions on human rights violations in Israel, these bodies start to recognize the general principle on state sovereignty on migration. Then, on a second base, they point out that states' power are subjected to limits when it comes to protection of human rights, even when migration powers, control powers are at stake. So, legal scholars claim that a protection par ricochet, or a derivative protection of migration rights, was developed. This modus decidendi continues until this day, as the most recent case is decided by the European Court of Human Rights state. The reason behind this side protection is developed, and the court have already stated that it does not cease in times of crisis. And it requires that in a migration decision, states must analyze every time in an individualized way all requests of entry or stay of foreigners in the territory in order to understand whether a possible human right might be at stake. As a consequence, automatic or collective decisions where no such analysis is made are not to be allowed, and they may encompass disregards for possible human rights. Indeed, international human rights forbids collective or automatic decisions in matters of migration, meaning decision taken with a view to a group of people in their entirety, without regarding to the individuality of the members of the group. The most problematic types of these measures that we have witnessing during the 2015 crisis are undoubtedly the collective expulsions or pushbacks at seas. In fact, in such cases, the state is not in a position to ascertain whether, among the various persons in the group, there might be some migrant who may have a fundamental right to enter and to be protected in the territory. The European Court case law in this realm has always been based on this reasoning regarding the context of question. In several judgments during the so-called refugee crisis of the 2015, the court stressed that the constant context of crisis in no way diminished the guarantees of migrants' human rights. Even if states were facing mass migration, they were still being responsible for breaching the European Convention, including for disrespecting prohibition of collective expulsions. The court considered that the state's arguments, namely Italy, Greece, which claimed that migratory flows were massive and that it was impossible to take in account the individual situation of full persons, were not compelling. So, for example, in 2021 and 2022, several convictions were also issued, including hot returns at the Croatian borders from Poland and from failure to receive and examine asylum applications. Greece was also convicted for violating the right to life by admission of help with due diligence in a case of a boat full of migrants that sank in the Mediterranean, leading to a loss of migration lives. In this case, which was Safi against Greece, I have to point out that it was elected by the blog Strasbourg Observers as the most important case of 2022, because it was considered that by not helping a boat from sinking, Greece has breached the fundamental right to life. So in practice, let's now move to what is happening in states as observing or not, this need to observe individually all human rights of people seeking to enter in their territory. And I might call this third chapter as the non-application in practice of international migration law's traditional response. Indeed, despite the broad acceptance that all migration decisions must take into account all human rights of migrants, despite the several decisions of human rights bodies that have convicted the defaulting states, the reality has been showing a failure to apply these principles in practice, mainly in the last scenarios of migration crisis. The practice of some states is indeed far from showing a full respect of these principles. Unfortunately, it has not been just a limited group of specially restrictive states. The problem seems to be widespread. Although some international legal scholars and political scientists have argued for a long time that there is a crisis of sovereignty or a crisis of a sovereign states, in the context of migration, there has been a real attempt to reaffirm and reinforce the state's sovereign powers. This has been evident in several contexts. First, in the framework of the European integration. Since the Treaty of Amsterdam, the EU developed an area of freedom, security, and justice. The Lisbon Treaty, it has created common asylum and migration policy. However, the progress of this policy is constantly being subjected to complex challenges. It has been mainly developed through directives aimed at creating a minimum standards of harmonization, and they provide for abundant exit doors, meaning that there are real deference mechanisms to the sovereign powers of states that allow them to maintain the last word in the matter of migration control. The new EU Pact on Migration and Asylum that has been approved in 2024, it's no exception to this. Although it is mainly based on regulations, these regulations do provide some optional clauses which seems quite contradictory. It is the reason for this is that states are still willing to preserve some margin of discretion when it comes to decide migration. Indeed, at the present moment, November 2024, the pact should be already in force as long as states have time to implement it until 2026. But some states are claiming that they are no longer interested in implementing them. Some of them consider the pact to be too strict, others consider the pact to be too permissive. So this shows how it is so difficult to reach an agreement on migration and asylum. Resistance to the development of a common immigration and policy was also evident in 2015 when some member states strongly opposed to the EU Council's decision on relocation of asylum seekers. The relocation decision was aimed at redistributing asylum seekers of certain nationalities who had arrived and were staying in especially burdened states, Italy and Greece. These countries, indeed, were severely affected during this crisis, where the majority of migrants arrived through the Mediterranean or Aegean seas to their shores. The idea was that all member states should receive a quota of migrants in their territory. This measure was based on a fundamental principle of the EU, the principle of solidarity between member states. The Council decision provided that each state should receive a minimum number of asylum seekers, which would be calculated according to a set of factors, such as the gross domestic product, the unemployment rate, population, even the state's territorial area. However, some member states disputed this measure, claiming precisely that it disrespected their powers of territorial sovereignty. The persistence and reinforcement of these sovereign powers also explains why there is no recognition of a right of entry into the state's territory to seek asylum. This is a noteworthy lacuna in international refugee law, which is hardly consistent with the human right to seek asylum that is enshrined in Article 13 of the Universal Declaration of Human Rights. This article provides the right to seek and enjoy asylum in other countries. However, it has been understood that it does not fall in a specific way on any state of the world. So, states are not obliged to authorize the entry into their territory in order for a foreigner to apply for asylum therein. The 1951 Geneva Convention also does not solve this problem, as it does not even mention a right to asylum. This lacuna apparently was not unraveled by Article 18 of the Charter of Fundamental Rights of the European Union. even though it protects the right to asylum, apparently stronger than one of the Universal Declaration. Some scholars claim that it does not encompass, indeed, a right to enter in the territory to seek for asylum. And the European Court of Justice has always avoided to affirm such right. The result of this imperfection is somehow paradoxical. States are bound by international law and this Geneva Convention to protect refugees. But at the same time and in practice, they strive to prevent asylum seekers from reaching their territories. Indeed, in practice, states have tried through different means to block the entry of asylum seekers in their lands. For example, through collective removals and the already mentioned pushbacks, or even through the creation of real no man's land, meaning artificial border zones in which applications for international protections would be registered without allowing asylum seekers to formally enter in the territory. These actions have already been condemned by several occasions by the European Court of Human Rights. Indeed, recently, this court's case law has opened slightly the door to a possible evolution in the matter by protecting the effectiveness of a right to apply for asylum, the corresponding duty of states to register and examine the applications. The court considered that such right of access to the asylum procedure stems from Article 13 of the European Convention, which protects a right to effective remedy. In the court's view, this right implies that states cannot refuse to register asylum applications. Even so, as said, the resistance of states to bestow their sovereign powers of excludendi and excludendi persists, and this has been aggravated by today's mass migratory movements. These movements have been proven to be a real challenge to the maintenance of the current paradigm of international migration law, which, as demonstrated, is still based on the affirmation of state sovereignty and on the protection of individual human rights. The mass arrival of migratory flows is leading to two consequences. First, states feel that they are being invaded by the others and that their territorial integrity is at risk. Concerned with defense of their territory, they act through illegitimate measures, such as mentioned pushbacks or refusals to register asylum applications. Although they do not expressionally rationalize these actions on the grounds of international law, some states seem to be convinced that they are acting legitimately, perhaps a state of necessity which would aim the superior purpose of defending their borders. Such a public interest perhaps would be seen as prevailing and justifying legitimate actions, such as collective expulsions or denials to access to asylum procedures. However, since in most cases there is no attempt to provide a justification for such illegalities, states must be simply fully convinced that it is basically impossible to respect international human rights law in practice due to the massive arrival of migrants in the territory. Such a factual finding is obviously not legitimate or sufficient to justify illegal actions pursued by states. Moreover, a putative ground on a state of necessity is doubtfully admissible. Indeed, it's questionable that arrivals of migrants have such characteristics that make impossible other less serious actions than those that entail violations of human rights. On the other hand, some of the human rights disrespected are, at least in two cases, not subjected to any restrictions. That is the case of prohibition of torture, inhuman and degrading treatment, as well as the prohibition of collective expulsions, which do not allow any exceptions. It must be noted that these repressive actions have not had the effect of stopping or even significantly decreasing the human flows. Migration has been able to circumvent the tighter state controls by opting for increasingly dangerous routes, also by using criminal networks. The crossings are thus increasingly life-threatening, with migrants permanently and desperately trying to bypass the adverse natural elements and the state's violence at the borders. Restrictive measures and violations of human rights on the state sides, illegal immigration and criminal networks on the migrant side correspond to the current state of affairs. We are witnessing to a return to a state of nature on both sides of the migratory phenomenon. They both act as there is no such thing as international migration and refugee law. This clearly demonstrates the unsuitability of the traditional responses to international and European migration law to the current challenges. It is time to ask how the traditional legal paradigm that is unacquirable, outdated, can be replaced in order to actively respond to the current and future migratory changes. And now I move to the fourth and last chapter about precisely a rehearsed response to the current crisis. So, in the context of the two last called migratory crises, different responses were tried in the European Union in the 2015 crisis and in the 2022 crisis. As already mentioned, the first crisis consisted of mixed flows, composed of persons mostly coming from the Middle East and Sub-Saharan Africa, who reached mainly the coasts of Italy and Greece. Initially, the European Union issued a decision on temporary relocation of asylum seekers, which, as we have seen, was intended to redistribute some of those who have arrived and were staying in Italy and Greece. We have also already mentioned that this decision was opposed by some EU member states. Not being permanent, this solution functioned as a quick fix aimed at alleviating the population overload with which the two Mediterranean countries were confronted. When the relocation program ended, the ordinary rules governing the common system on immigration and asylum in the EU came back to force. As these rules provided to be dysfunctional in the context of mass migration, in 2020 the EU announced a new European Pact on Immigration and Asylum. This document was a political strategy that outlined guidelines for future migration crises. It was approved this year. It is based on a strong philosophy of political realism, which was inspired by the practical experience of the functioning of the Common European Migration Policy in 2015. It reaffirms the principle of solidarity enshrined in the treaties, provide answers for crisis and mass migration. It stressed that all states must collaborate in the combat and the effort of managing migratory flows. However, it accepts that such collaboration may be done in different ways. In particularly, states that don't want to receive necessarily migrants may contribute in other ways. So it expressly accepts that some states may participate in the effort through material or financial support instead of receiving asylum seekers in their countries. It's easy to see that this option was intended to respond to a foreseeable opposition of some member states. They perhaps would not be willing to accept new orders from Brussels requiring them to receive a quota of asylum seekers in their territory. However, this solution has been harshly criticized by legal scholars and the civil society at large. Several voices point out that the European Union has given in into the demands of states that wanted to evade their responsibilities, responsibilities that stem not only from the European Union, but also from international refugee law itself. However, it is believed that once again this was the possible consensus in a realm that is increasingly controversial in European integration. In addition to other measures, the new Pact on Migration and Asylum also provides for processing of asylum application in transit zones. I'm referring to a specific regulation. These zones were created to manage the selection of migrants, technically before their entry in one of the EU member states. It was a solution of the hotspots, which had deserved severe criticism in the past, because migrants' applications would be treated in a no man's land. Indeed, this solution leads to several doubts as to which state is effectively exercising its jurisdiction on application that are decided in transit zones. It is very likely that the future developments on EU migration law will be based on the strategic lines stated in these facts. Some evolutions have been waiting for so long, as this is the case of a reform of the Dublin regulation and others. The second response tested by the European Union to a crisis of massive migration flows took place in 2022 and consisted on a temporary protection of persons fleeing the war in Ukraine. In this case, the measure adopted was completely different from the responses tested in 2015 and the new responses dealt with by the 2024 Migration Pact. These new responses for Ukraine were based on the activation for the first time in history of the Temporary Protection Directive. This directive was developed and adopted in 2001, so 20 years ago, more than 20 years ago, following the flows of displaced persons from the war in the former Yugoslavia. The aim of this instrument was to create a rapid response to situations of massive migration due to conflicts. However, it would take more than 20 years before this instrument was activated for the first time. The fact that it was not triggered during the 2015 refugee crisis led to criticism from several authors. Here, as now, also there was a mass migration due to conflict, namely the Syrian war. But only due to Ukrainian war was this directive activated. This directive sets for a system of automatic protection to a group of displaced persons fleeing war and following a decision issued by the EU Council. This decision declares the existence of an official mass influx of persons and sets forth the criteria that displaced person must fulfill in order to benefit from such automatic protection. This legal scheme provides protection to groups, and therefore authorities do not need to make an individualized and detailed analysis of the personal case of each migrant. This solution in no way disregards current international law, which requires states to analyze individuality. Because in this context, the automatic and collective decision is intended to protect the group, and at most may err in the side of caution by eventually covering those who would not need protection. The application of this directive remains limited to displaced persons fleeing the war in Ukraine. Thus, currently, two different responses to massive flows of displaced persons fleeing war are applicable in the EU. The Temporary Protection Directive for displacement in Ukraine and the ordinary rules of the European Union's migration and asylum system for others. The discussion of the reform of the latter in the context of the European Pact on Migration and Asylum should have ceased after its approval in 2024. but uh, meanwhile, it is still open. So, which ideal solution should we think for mass displacement due to wars? Asking for ideal solution to the management of current and future migration flows seems utopian. Besides, two different types of responses to different groups and flows currently coexist in the European Union. And this coexistence shows that there is not just one ideal solution and that the measures to be adopted in the face of migrant flows can and will continue to depend on the special characteristics of each scenario. Indeed, such coexistence is justified by the fact that we are before two very different phenomena. In the case of the displaced first persons fleeing the war in Ukraine, it is a homogeneous flow. People are all fleeing due to the same cause and are all seeking a safe place to live in. In the case of migration flows originated in the Middle East and in the several countries of Africa, people come from different geographies and migrate for different reasons. Due to the heterogeneous feature of the latter, a scheme providing automatic protection to all those who arrive on EU shores might not be adequate. On the other hand, in the case of the war in Ukraine, it is believed that displacement would have a temporary nature. Besides, in that case, migratory flows come from a country that has direct borders with some EU member states, contrarily to what happens with the flows coming from the Mediterranean. This proximity, or rather geographical immediacy, required that the response to the displacement of persons from Ukraine would be different. Indeed, the first country that displaced persons encounter in their search for safety is a EU member state. And the EU rules that refer to the safe third country alternative in the sense that asylum seekers who have previously passed through other countries that can be safe options before going to the EU would therefore not be applicable in the context of the Ukraine displacement scenario. Having said that, a possible temporary automatic protection mechanism with the same characteristics as those applied in 2022 to displaced persons fleeing Ukraine may work for migratory flows that gather the same characteristics, homogeneity, and temporarily. However, as previously mentioned, it is believed that migratory flows in the future will be predominantly heterogeneous, gathering simultaneously people fleeing from armed conflicts, fragile states, and tyrannical political regimes, climate change, environmental disasters, precarious economic situations, among others. Some armed conflicts may continue in the future, others may worsen, and one cannot exclude the emergence of new ones. Some causes of displacement may well become permanent, as we have witnessed with the Palestinian refugees. And that will be also the case of some climate changes. So, migrations motivated by desperation, migrations searching for better conditions of living will continue to exist, has always existed throughout human history. If states persist in strengthening their unbridled fight against migration, challenge to their territorial integrity are likely to grow rather than diminish in the face of the incessant and inescapable desperation of migrants seeking to enter their territories. Perhaps the adequate responses for future challenges is the approval of flexible instruments that can be adapted to different types of migratory flows. We have been witnessing to the emergence of hybrid instruments of public international law in this area. The Global Compact for Safe, Orderly, and Regular Migration is an example. It does not have a binding force, but was upheld by an overwhelming majority of member states of the United Nations. This instrument was created by taking into consideration a central premises that states alone cannot manage adequately the challenge of the future migrant flows. It is recognized that these necessary responses to such challenges will have to be made in an integrated manner and at the global level, especially through what we may call a global governance. In this case, such governance would have to include the various states involved in the migratory process, meaning the states of origin, the states of transit, and the states of destination. Solution of this kind is based in several ideas. First, is the premise that migration cannot continue to take place in a disorganized and unbridled way. A disorganized migration represents a big challenge to the territorial integrity of states, to their public order, and to defense of legality, also to the effective guarantee of human rights of migrants. Secondly, any solution must recognize, as the Global Compact on Migration does, that states do not have the capacity to manage migration flows individually. In addition to involving all affected states, the management of migration would also be more effective if a certain form of central administration at the level of the United Nations was to be created. But a possible central entity would have naturally to be seen as a simple management mechanism whose actions should respect as much as possible state sovereignty, namely regarding decisions on their reception capacities. On the other hand, such a solution could adopt the realistic perspective that not all states in the world, even those with reception capacities, are willing to welcome as many migrants as they could. Therefore, one should not exclude completely that some states could simply and exceptionally participate in the overall burden of managing migration through other ways, including through contributions to their neighboring countries or the country's migrants of origin. In any case, such exclusion could not be the rule. Otherwise, we may witness a global abandonment of the willingness to welcome. In fact, a solution for the global management of migration may combine the two answers: contributions through material or financial help, also through welcoming in safe countries with reception capacities. The European Pact on Migration and Asylum somehow already adopts this perspective. Such solution would require states to trust the international community and to accept some restrictions to their powers of use includendi et excludendi. Finally, as regards the specific mechanism to manage asylum-seeking flows, the most safe and adequate mechanism continues to be the resettlement of asylum seekers, both from neighboring countries or directly from the countries of origin. Large-scale resettlement ensures that displaced persons can be prepared in advance in order to be duly integrated in host countries, and it also allows host countries to be prepared in advance to receive asylum seekers according to their reception capacities. Resettlement, furthermore, provides international protection in an equitable manner. It has the potential to reach all migrants in need, not just those who, for many reasons, were able to reach safe countries through their own means. Furthermore, it allows asylum seekers to reach host countries by legal means, thus avoiding the criminal networks that are engaged in trafficking of human beings and smuggling of illegal immigration. It is true that the solutions that we are now putting forward do not solve everything. Although being a reliable and safe mechanism, in practice, resettlement has been facing many challenges. The number of available resettlement vacancies in host countries remains clearly insufficient for all asylum seekers wanting to be received in a safe haven. As a result, thousands of lives of asylum seekers are suspended, waiting to be selected in refugee camps that sometimes do assume the dimension of true metropolises, and which generations of families silently succeed each other. However, there is some hope because the new EU Migration Pact, although has many gaps, does provide a regulation for resettlement, meaning that EU will adopt in the future common resettlement programs in which all member states should be engaged. International migration law must therefore be reinvented, lest the state of nature that is currently taking place with irreparable damages both to the human dignity of migrants and to the sovereignty of states can be ended. Perhaps this reinvention may follow some clues outlined in this paper, which undoubtedly need deep reasoning in order to be able to respond to this very complex and challenging phenomenon that will be mass migration due to conflicts in the 21st century. Thank you very much.